Welcome, Litigation Nation. I'm your host, Luke Behnke, alongside my co-host, Jack Sanker. For those of you new to the show, this is the podcast where we recap the most interesting legal news stories and talk about what you need to know. Jack, what have you got today?
So Ed Sheeran, he's not liable for copyright infringement against Marvin Gaye after taking the stand in his defense and teaching the jury a bit of music theory.
Montana enacts new legislation regulating third-party litigation funding in that state, and the oldest active U.S. federal judge sues to halt the competency probe against her.
Luke, you remember the McDonald's hot coffee case from the 90s? Well, we've got a new one, and we'll be covering that today as well.
All that and more coming your way. Here's what you need to know.
Up first, a rare intellectual property law story on this show, but this is kind of a fun one. Ed Sheeran was recently sued for copyright infringement over a Marvin Gaye song. Specifically, he was accused of copying a musical chord progression from Marvin Gaye's classic Let's Get It On with his 2014 song Thinking Out Loud. Now, I know artists regularly sue each other for this kind of stuff. Basically, when a song sounds too much like another song, the original artist or whomever has the rights to the original artist's music can sue for copyright infringement to grab a piece of the revenue that the new song may be generating, and that's generally what happened here. Anyways, I wanted to share the story because of how Ed Sheeran defended himself at trial. Now, at trial, while on the stand, Sheeran actually took out his guitar and gave the jury a demonstration of chord structures and how they're being used in different songs. Specifically, he strummed a common chord progression and sang song lyrics to different songs over the same chord progression, showing that many pop songs borrow from each other in ways that aren't quite, quote, stealing. And I just want to play a clip for you all here of him being interviewed by Howard Stern after the fact, where he kind of demonstrated how this testimony went.
You sat down with the jury, and I think this is great, and you took out your guitar and you said to the jury, you think I ripped off this song? I'm going to play you something now and show you how similar things can be. What did you play for that jury? If I was the jury, what did you say to them?
So it was, so my one is, when your legs don't work like they used to before. And then there's, have I told you lately that I loved you? And then, people get ready, there's a train coming. And then, what was the, looks like we made it. Look how far we've come, my baby. And oh, she breaks just like a woman. I mean, there was 101 songs that, and that was like scratching the surface. There was like 101. You know, there's I guess you say it's really. And what I was saying is, like, yes, it's a chord sequence that you hear on successful songs, but if you say that a song in 1973 owns this, then what about all the songs that came before? We found songs like from like the 1700s that had similar melodic stuff, and then there was like huge songs in the 50s and huge songs in the 60s, and it's just, no one's saying that songs shouldn't be copyrighted, but you just can't copyright a chord sequence. You just can't.
It's a really cool use of demonstrative testimony to illustrate a point to a jury that I don't think a jury may have grasped unless you actually kind of played the music for them. Very cool trial work, good work by Sheeran's attorneys at the firm Pryor Cashman, and a good example that when you can distill your sort of complex legal argument into common sense terms, juries can make really smart decisions, even on complicated topics such as copyright infringement. And Luke, I highlighted this because, one, it's an interesting story, and two, I just think it's really good trial work here. I think that Sheeran's attorneys understood that explaining, complex aspects of both copyright law and music theory, really in like the dry technical terms, is probably going to put the jury to sleep. I can't imagine being a jury in like a copyright case. I mean, I think that sounds awful to me. But when you actually explain to them, this is why this matters, and here's an example of how this kind of would look in the real world, it's really compelling. I think it's a very simple argument, which is, how can Marvin Gaye own the copyright to this chord progression when there's 100 other examples, and I'm going to show you them all right now. I think that's frankly really compelling testimony, and it's a compelling argument for Sheeran's version of the case. What do you think?
Yeah, I agree. I think demonstrative evidence can be a very powerful and persuasive thing to a jury rather than getting talked at. prefers to sort of see things with their own eyes. And if you can demonstrate, what you're talking about for them, I think you've got a much higher likelihood of success. Much like, watching surveillance in a personal injury case can be pretty powerful and persuasive. One sort of similar instance that I can, draw upon from my experience is we had this forklift case in federal court, and our client actually had the box of this forklift, kind of recreated. And we put that in front of the jury and kind of showed, where the operator's foot was, and the plaintiff kind of tried to use it and show, where the foot might have been. And it was interesting. And ultimately we were successful defending the forklift manufacturer, but that's just that's an example in a case. And I think the jury, in that particular matter, in this Ed Sheeran matter, really appreciated kind of seeing that demonstrative evidence.
Yeah. What do they say? Show, don't tell. And,
exactly.
And this is, I just think that the Sheeran, actually having, and by the way, he's like a world famous pop star. So you as a member of the jury get, your private little concert from, a guy who sells out stadiums. I think that there's some element of, reminding the jury that, hey, he's super famous again, and you should be starstruck in this moment. And I hope you take that back to the deliberation room when you're thinking about whether he infringed on this copyright or not. Just great trial work. It's a really cool way to demonstrate their argument in a way that makes total sense, by the way. All it takes is, that 45-second clip that I played, and you go, oh, yeah, that's a great point. It's, really, really simple.
I think I'm going to start all of my trials this way. So my first witness will be like Justin Bieber.
Yeah.
See what the Biebs is doing. Get him up there.
If you could drop a subpoena on him, why not?
I'm going to win them all. For those listeners who didn't catch our last episode on litigation financing, third-party litigation financing is an arrangement where a funder who is not a party to the lawsuit agrees to help fund it. Funders are typically private firms, or can be private firms, operating large investment portfolios who expect to get a payout if the suit is successful. Montana becomes the latest state to enact new legislation which regulates this third-party litigation funding. The legislation in Montana requires lawsuit lenders to register in the state and makes judges, juries, and defendants aware of a third party when they're financing the litigation. The governor signed the bill into the law last week, and the president of the American Trucking Association says, quote, "The civil justice system is not a stock market, but that is what it's becoming with the rise of third-party litigation financing," close quote. He believes that this is a common sense measure, and it will bring lawsuit lenders, quote, "out from the shadows and make the fact finders aware that a disinterested third party has a financial stake in any verdict," close quote. Now, the president of the ATA, that's American Trucking Association, expects other states to follow Montana's lead in, quote, "ensuring full transparency behind this," what he calls a perverse and shady practice, close quote. Obviously, that's one side of this issue. Proponents, as we discussed in our last episode, take a different approach. They contend that litigation funding keeps plaintiffs in the game longer, levels the playing field, and it puts litigants on equal footing with defendants who are often well funded. So, Jack, this is a relatively short story, and I highlighted it only because, as we've discussed on the show, litigation financing is certainly on the rise. This is yet another state. I think the count is up to like maybe somewhere around 16 states that are starting to regulate litigation financing in some way, at least making these litigation funders kind of disclose who they are. There's been work at the federal level to amend the federal rules to disclose these litigation financiers. So it just sort of illustrates where this is going. You have any thoughts that you want to add?
Yeah, you know what? I actually I do kind of have a bit of a spicy take on this. So this Montana law is requiring the automatic disclosure of any third party litigation funding, right?
That's right.
And it's the bill's passed, and the folks in Montana whose interests this is intending to serve are celebrating. What if I told you that this exact same bill was passed in Wisconsin 2 years ago, and to my knowledge, no one cares? Um, as someone, I mean, you practice mostly in Wisconsin. Does it even come up?
Well, so I'll say this: we have started to include these requests in our discovery requests, and so we'll ask plaintiffs to identify litigation funders. By and large, though, Jack, I will say that it hasn't it to my knowledge, it has not delayed resolution of a lawsuit. I don't know if I would go so far as to say it's a perverse and shady practice.
Right.
But I do think that it at least helps us get a matter to resolution if we know who the players are, who the interested parties are.
So I think it's definitely relevant, and it's a good if you want to know who the stakeholders are, what it's going to take to get a number, to get to a number that's going to satisfy everyone. Technically, under the law, the loan providers, they technically have no right to interfere in that process, but in practice, it doesn't exactly always work that way, as we know. But what I can tell you is, from both of us that are doing this, when we actually are litigating these cases, you get that information. Great, that there's a loan for X amount of dollars on that case. It's not admissible at trial. It's not relevant. What are you going to do with that? Are you going to argue that this plaintiff owes money? Like, that's, if anything, that's arguably sympathetic to a plaintiff who had to borrow money at like this loan shark rate of 30 something percent. I'm not blaming the lenders, by the way, but that's what the rate is. So I've seen it. I saw that in Wisconsin when this bill was passed, pretty much the exact same bill, and the kind of Chamber of Commerce adjacent, like, pro-business interests kind of were celebrating, and they were saying this is gonna maybe stop the influx of third-party finance money, because now they have to show. Well, I just don't see that it has had any effect at all, and I don't think it will in Montana. It's great to know, I suppose. It's interesting to know, and it can impact maybe how you make a few decisions while you're actually working on a given lawsuit. But it is not a smoking gun. Certainly, it doesn't. I don't think it helps a defense at trial very much at all. I don't think it's admissible or relevant, frankly. So to the extent that the folks in Montana think this is going to change things, I just don't think it will.
Yeah, I'm with you. It's not a silver bullet. I think if progressing toward the ultimate goal, which is to get rid of litigation financing altogether, I mean, sort of, if that's what their ultimate goal is, yeah, I suppose this is a step in that direction.
But we know that's not even close to happening. It's the opposite is happening.
The opposite is happening, and that's the point I was going to make. You said, look, if they thought that this would scare these large funders away from funding lawsuits, well, the opposite has been happening. I mean, this business is from everything I've seen, this business is exploding, and I don't see. I'm with you. I don't see mandatory disclosure as a silver bullet for getting rid of litigation funding. In fact, I think litigation funders will probably proudly wear that on their sleeve.
Yeah, it's free advertising.
Exactly. Judge Pauline Newman, who we talked about in a past episode, she's under investigation for her performance on the bench, has since sued the appeals court's chief judge and others in Washington federal court, seeking to block their investigation into her fitness to hold office. Newman, who our listeners may recall is 95, alleges in her complaint that the probe violates her constitutional rights, and she denied that there were legitimate concerns about her mental and physical capacity. She's asking the district court to halt or transfer the investigation. Judge Newman's lawsuit claims that the orders justifying the probe were, quote, riddled with errors, close quote, describing as false an assertion that she was hospitalized after having a heart attack in 2021. According to Reuters, Judge Newman says that she served on more appeals panels than most of her colleagues and issued at least 8 opinions that summer. That's back in 2021. And that her productivity has not dropped over the past 3 years. The complaint further states that the committee investigating her gave her only a few days to comply with her requests for mental evaluations and her private medical records, which she calls a baseless invasion of her privacy. So, Jack, I don't suppose that your sort of take on this has changed much since our last discussion, but I thought that it's only fair to kind of follow up on this and remind everybody that there are sort of 2 sides to every story. Judge Newman here is clearly not impressed with this investigation.
I think it's good that we're at least trying to tell the other side of the story now that we have a little information. And it does kind of beg the question, is if there's something else going on here. I don't know. I mean, I'm way off the rails and speculating here, but it does not, because one of these parties is like way wrong, and that's the only out. One of them is absolutely full of it because just the way that the facts are being presented, and that to me is, it doesn't seem like there's like a benign misunderstanding. It seems like one side is completely off base here, and that just smells a little weird.
Yeah, I mean, this kind of stuff never becomes public, and this is a very public spat. Curious to see how this ends up. I mean, that's the really interesting thing here, right? If you've got this investigation into this judge, and she's filing a complaint that says that this is a baseless invasion of her privacy. Like, how do you walk any of this stuff back, Jack? I mean, this is like, what are you going to remove a federal judge from the bench, and set a precedent for that? I don't know. I think, again, me looking into my crystal ball here, Judge Newman, there's no way Judge Newman is going to get removed from the federal, but they're not going to remove a sitting federal judge.
Absolutely agree.
So, all you've done really is, call attention to this, made this issue very public and really upset someone who served for a very long time, since 1984. She was appointed in 1984 by President Reagan.
Yeah, and I mean, we talked about this our last episode, and where there's really not a great way to deal with this scenario, other than you hope behind closed doors, if there really is a mental capacity issue, like there is a genuine. I'm not suggesting there is here. I don't know anything about this judge, but if there actually is, you kind of hope that folks would just sort of nudge the judge, behind closed doors and kind of get them to voluntarily, walk off into the sunset. To do it this way is like, something really must have happened. And for the judge to, because if those that are making the allegations are correct, I mean, this is the biggest example of not taking the hint that I know of in the past few years. And so, either they're completely off base or this judge who is completely aloof. And like, I doubt that's the case because, one, she's a federal judge. Two, I'm sure that she has attorneys and folks that are working on her behalf and she's consulting with and who have told her that this was a good idea to file this. So I don't know, man. It's really interesting to see how this happens. You don't see anything like this. I don't remember ever seeing anything like this before. It's really, dirty laundry of the federal judiciary just being aired in public.
Yeah, as we outlined last time, there are precious few examples of federal judges being removed from the bench in the past. I'll keep an eye on it and update everyone, because I agree it's interesting because it's rare.
most of you probably have heard of or remember the McDonald's hot coffee case from the 90s. If not, go ahead and Google it. It was, to me, the first lawsuit that I actually remember learning about. And this was, I would have been like 6 years old when the hot coffee case was in the news, like 6 or 8 years old around then. I remember it was the hot coffee case and there was the OJ trial, or like the two things that are like in my mind is like learning what a lawsuit was. Back in the 90s, there was a woman who spilled a cup of boiling hot, what turns out to be like boiling hot coffee on her lap. She suffered actually a lot of horrendous injuries because of it. There was a lawsuit, there's punitive damages awarded, and a lot of people didn't like that. It was kind of a cultural touchstone for a while. Like the late night TV host like poked fun at her for spilling coffee on herself. But when you look into it further, it turns out, there may have actually been some wrongdoing here. Anyways, it's a great cultural touchstone of the 90s if you want to put yourself in that headspace. Finally, we have our own version now. Us millennials and I guess the younger generations, we have our own McDonald's hot food case, and this is a hot chicken nugget. On May 12th, which is today as we're recording this, a jury in Fort Lauderdale found that McDonald's and the franchise operator for the specific McDonald's liable for an injury that allegedly occurred when a McDonald's chicken nugget fell onto a girl's leg, causing second-degree burns. The girl was, I believe, 4 years old at the time. Jury found McDonald's liable for failing to provide instructions for handling hot food, the franchise operator liable for negligence and failing to warn customers about the hot food. And here's kind of just a quick and dirty summary of the facts here. The mother of the injured daughter, her name is Miss Holmes, bought her daughter a Happy Meal. The girl was about 4 years old. She handed her the Happy Meal, and then as the car drove away, the little girl started screaming. Miss Holmes took photos and videos from immediately after the accident showing the burn, and the child's screams were actually played in court. The child is autistic, and she did not testify. What's interesting is both sides actually agreed that the chicken nugget caused the burns. There wasn't a dispute on, kind of the key facts on liability here, or on causation at least. They fought over how hot the chicken nugget actually was. McDonald's said it was no more than 160 degrees. The plaintiff said it was over 200 degrees. Regardless, they agree that this chicken nugget burn was second-degree burn in her leg, which is a partial thickness burn of the epidermis and dermis. And as we sit here today, the case has been bifurcated on liability and damages. This was the liability trial, so we know that there is liability. The actual second trial is set for this summer on damages alone. And when I came across this case, I was just transported back to being, 7 or 8 years old and listening to my dad complain about how a woman can spill hot coffee on herself and get $100 million, and how that was, that wasn't fair, et cetera. And then I went to law school and learned all about that case. And now we got our own to think about, Luke.
That's right. And same. So my dad, firefighter, captain on the fire department growing up, big proponent of personal responsibility. And so he's kind of that guy that's like, look, that's what this country has come to. This is America these days. You can just, right. Go stub your toe and sue someone for $200 million. It's like, yeah, Dad, were you sitting on the jury? No. All right. You have no idea what you're talking about. The facts of that coffee case are actually pretty compelling if you actually dig into it. But yeah, the PR spin around it made it.
It was like spoofed on like Saturday Night Live and like Letterman. Like they made fun of this woman for like years after this. I mean, the PR that McDonald's was able to pull off is, pretty impressive from their perspective, especially after like the, $100 million verdict or whatever it was.
So I'm wondering, yeah, I mean, this is the same sort of situation, right? I don't really know the facts of this case, but man, if a chicken nugget is putting like second degree burns on your leg, I don't, call me crazy, but that's too hot, right, Jack?
Yeah, it shouldn't have. It's like, regardless of what happened, how it ended up on the girl's leg, like you shouldn't be handed a radioactive chicken nugget, like by any. It shouldn't be that hot, like no matter what.
Right.
And if it is, like, let it sit for a minute before you give it to the customer. Like, let it sit. So yeah, I mean, I actually, especially because McDonald's appears to have rolled over on the causation aspect and the fact that it did cause a burn. In my mind, I'm like, well, it's a Happy Meal, which means it's got a little toy in it. It's like intended for little kids, That in particular jumps out to me as like a factor. I didn't see it discussed in anything I read, but I bet it was a trial that this was like a product that's designed and marketed towards little kids. And then you're going to put like an actual on fire piece of meat in there and hand it to them. Like it's only a matter of time before someone gets burned. So yeah, I mean, we'll see what happens. I'm really interested in the damages portion of this trial. Hope the little girl's okay, obviously. But I'll be interested to see if there's a discussion on punitives the same way that there was in the original hot coffee case. And then I'll be interested to see if the media, how they spin it this time around and see, whether things have even changed at all since the 90s.
So that's something interesting that you raised here. And maybe that's something that you can explain for the listeners, Jack. So there's compensatory damages and then there's punitive damages. So even if the injury itself isn't horrible, right? I mean, or it's not permanent, it's temporary, there's compensatory damages for that. But the really big numbers come out when you're talking about punitive damages. It's two different things.
Yeah, and there's there's case law on this which describes when each is appropriate and when in what types of cases where punitive damages can even be sought. But in general, in an injury case, in most states, there's a heightened pleading standard, a heightened standard of proof. You have to show something on the lines of like willful and wanton conduct or reckless disregard, which is a step higher than negligence. So you can't get punitives if you prove that there was just a breach of a duty of care. You have to prove that breach was caused by a neglect to the level of being willful. And so you'll get punitives in cases where the tortfeasor, the bad actor, the person who's at fault, maybe knew that this bad thing was going to happen and did it anyways. So in the famous hot coffee case, the punitives in that case were based on the fact that lots of other people had been burned by that scalding hot coffee, and they just continued to hand it out anyways, but they didn't change their practices. And then there was more evidence, I believe, that the temperature in that coffee was like at that temp to dissuade people from taking advantage of the limitless refills, because the coffee took so long to cool down because it was practically boiling that like you'd have to sit there all morning if you wanted to get a refill. And so that was like the basis for the punitives in that case. In this case, I don't know. I mean, I have no idea, but yeah, I suspect that there will be a discussion on punitives, if and when this goes to trial I think it's set for trial in July. Thanks, everyone. That's the show. Reminder, you can always find us on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. New episodes drop every other Tuesday, and we'll talk to you next week.